I requested a visitation and child support modification in December of 22, and they said there's no timeline on when it's going to get done. What can I do about that? Okay, that's the question that we've had, that we've received. I'm told attorney James Worth. I'll see if I can answer that for you, and that's a common one. And I've got some questions, okay? So it says, the question here is, I requested visitation and child support modification. So how was that request made? I'd like to know, if it's child support modification, a lot of times people will talk to child support enforcement with DHS and tell them, hey, I'd like to modify my child support. That my income went down or their income went up, whatever, I want a modification. So when you say you requested it, did you request it to DHS, or are you talking about formally requesting it, which would be drafting, signing, and filing a motion to modify either in DHS Administrative Child Support Enforcement Court or in a county court in the state of Oklahoma. So if it is just a request to DHS Administrative, well, that request to them, that's not a formal filing. That doesn't start the timeline on anything, and that can be a bad thing, because if you're wanting to modify child support, you're going to want it to be retroactively effective to the date of filing. Well, if you just made the request to DHS, that does not constitute a filing. So if it now, we're looking at going up on a year and a half, 2 years since this was filed. So if that's the case, then when it is finally granted, you can't go back to that date. You can only go back to the date that it was filed. So are we waiting for somebody to file something to start this, or are you waiting for it to be finished? Okay, so then if the other way, if it was actually something that was filed with the court, well, that does start it. So then I want to tell you that if you are the one requesting that it be modified, you're going to have to be the one to push it forward. The opposing party probably doesn't want it to be modified. If you want it to be modified, it's probably giving something to you, taking it away from them. So they're not going to want to push it forward. And the courts by themselves generally do not push family law cases forward. So somebody has to push it forward. If DHS is an interested party for child support purposes, sometimes DHS will push it forward. But you don't necessarily want to rely on that. So if you want the modification, there's no timeline because there's nobody pushing it forward. If you want there to be a timeline, you've got to file. So what would you do under those circumstances? You'd file an application to set a scheduling conference if this case is in county court. And then you could draft up a proposed scheduling order. And then when you show up for that scheduling conference, you request that scheduling order be entered. You can talk to the other side, work out an agreement on deadlines. If you can't agree to it, you can talk to the judge. The judge can come up with deadlines. But ideally, on that scheduling conference date, you end with a scheduling order entered as an order of the court that has deadlines for what needs to be done. So that would be deadlines to request and complete discovery. If mediation is going to be ordered, it's going to be a deadline for that. And then for a pretrial conference. And then at pretrial conference, you can get your trial date. So there's various things that can be done to move the case forward. The court's not going to move it forward on their own. The other side's not going to be incentivized to move it forward. Sometimes DHS just takes too long to wait for them to move it forward. You're going to be the one to move it forward. If you don't know how to do that, talk to an attorney. You can talk to somebody at my office by going online to makelawEasy.com.